Okay, welcome to our estate planning workshop. This is Estate Planning 101. I do cover quite a bit in here, but I try to answer the most common questions that we see from clients and the most common things searched on the internet. If you can do us a favor, if you're in a noisy area, please mute your microphone. If you have a question, there's three different ways to ask. There's a chat feature in Zoom. If you put it in the chat, I think Keegan and Jack are monitoring that. You can always raise your hand if you think we're right in the middle of something that pertains to your question, so that we cover it while it's fresh in your head. And otherwise, we're going to have a Q&A towards the end. I'll introduce a couple of the people up here. I'm Jayson Elliott. I'm the managing attorney at Bay Legal and one of the estate planning attorneys. Savindra Miraj is one of our other estate planning attorneys who's been working here for just over a year now. He just reached his first year and has done probably a couple hundred estate plans since he's been here, I would guess. Jack is going to help us today in coordinating and is a legal assistant. And my son Keegan is our Zoom host because he's good at the technology. Let's move on. So this workshop is for basically four categories of people. The first is if you own a home or any sort of real property in California. If you have children or plan to have children, if you run any sort of a business or have even a small side hustle, and if you maybe don't feel like at the end of the day that you need a trust or a will, well, everybody needs a will, but if you don't feel like you need a trust, it's also very informational for the future as your assets grow, or if you see them growing here in the near future. Okay, Estate Planning 101, everything you need to know to make decisions. And a lot of what we're focused on is what document is right for which people in which situations, because there's a lot of different avenues we can go in estate planning, and not everything is for everybody. So I'm going to try to break that down for everybody, so I hopefully cover each of your individual areas. I did see one question in the roster where we asked a question. Somebody was asking about transfer on death deeds. I'll cover that at the very end. It's not something we usually cover, but I'll cover that if it was one of you that asked that question. Okay, for a complete estate plan, there's four documents. There's a will, a revocable living trust, a durable power of attorney, and the advanced healthcare directive. These four documents create a system that cover us both if we pass away, but also if something happens to us and we're incapacitated, in that we can't make our own decisions, either because of an accident or because of some health related issues. The trust and entities are tools. The question is, what tool do I need when? Probably a quarter of every estate planning consult I do, the potential client or client wants to talk about LLCs or companies at the same time, because there is a lot of overlap. I will talk about especially LLCs a bit in this webinar. Well, when to use which and what structure should be. They're not exclusive. A lot of times we have LLCs or companies owned by a trust, or the reverse. So depending on your situations, we can stack things in different ways. Okay, the oldest tool we have in the state of California and almost every state is a will. A will goes hand in hand with probate. Probate is a separate court system, just like bankruptcy court is a separate court system. The probate court system is there to handle things when people die or they become incapacitated. The will does several things, but there's several things it doesn't do, which is why we have the trust option for a lot of things. A will tells the court what your wishes are. So it tells them who your beneficiaries are, what your property is usually, and tells them how you want things divided. A will does not transfer the property. A will doesn't have the ability to make the transfer. We have to have the court or the judge order the eventual transfer. So even though you have a will, after you pass away, if there's any property in the will, it's going to go to probate, and then the judge is going to follow your instructions. If you don't have a will, it still goes to probate, and then the judge follows a plan that we have set out in the state of California that says who gets your assets if you don't have a will. And I'll go over that in detail later. The will names your executor. That's the person who handles all the administrative aspects. They sometimes are the person that represents you in probate court, but it doesn't avoid the probate process. The will names guardians for minor children. This is one of the things a will does that a trust does not do. So even if you have a trust, if you have minor children, we still need to have a will. It's just it's really a very basic will. We call it a pour over will. Its job is to assign guardians for your minor children and to make sure anything that isn't in the trust, like things that aren't your real estate, your cars, your personal belongings, your clothing, your furniture, it puts it all into the trust. And then the trust in that case would handle where your assets are going. And that's the catch-all aspect of the will, is it takes anything that belonged to you upon your death and it puts it either into the trust or tells the judge in the probate court who you want it to go to. Okay. The primary reason most people decide they need a trust is to avoid what's on this slide. If you don't have a trust and you don't put your real estate into a trust, then there's very large fees for the probate court system. This is how the probate court system pays for itself. When you hire a probate attorney because your parents have passed away, you're not hiring that attorney like you hire a litigation attorney on an hourly basis. You're hiring them and they're accepting your case because the probate court already tells us what we're going to get paid if we handle your case. So the probate court itself also gets about half of these statutory fees because that's how the probate court gets its money to operate and exist. So for $1 million estate, which we all know in the state of California is a modest house in a modest community, probably in the Central Valley, you're going to pay about $46,000, or your children are going to pay about $46,000 out of the estate to the probate court, the probate attorney, and the person who's representing the estate for the court. So those funds come out of the estate prior to the property being transferred to your children if they're your beneficiary. The issue with that sometimes arises if the only asset you have is the house, then the court has to sell the house in order for the court to take its fees. And so your children are losing the house. They're still getting $954,000 approximately, but they are losing the house because unless they can finance it or find somebody to cover the fees for the court system. Now those fees go up. It's a little bit of a sliding scale, so it's not quite as big of a percentage on 2 million and 3 million, but you are looking at 130,000 plus on a $3 million estate. And if you have a house that's worth $3 million, but you have a $2.5 million loan on that house when you pass away, it's not based on your equity. It's based on the value of that property. So you can have a $500,000 in equity, have to still pay the court system $130,000, and only have 350 or so left out of that $2 million house. So even if you don't have a lot of equity, we really want to look at the trust as a vehicle for almost any real estate in the state of California. And so we'll go into the revocable living trust. Again, the key is you avoid the whole probate system if your real estate is in the revocable living trust. All right, how it works. You are the grantor and the trustee. You're the person who creates the trust. And as long as you, and if you have a spouse, you and your spouse are both the grantor and the trustee, then it's an exempt transaction. You don't have to worry about any property tax issues when you transfer the house into the trust or out of the trust. And sometimes we make many transfers in our lifetime because when we refinance the house, the bank will transfer in and out as they refinance. If you sell it, a lot of times we take it out of the trust at the time of sale. And when you buy a new house, you can then put it back into the same trust. The trust holds those assets. It can hold a lot of other assets, but real estate's the one that we don't have another way to handle in the state of California. So I primarily talk about real estate. And then the successor trustee, who is somebody that you choose, that's a friend or family member. Oftentimes for older people, it's their adult children that are also the beneficiary. You assign the person whose job it is and the authority they have to transfer the property out of the trust once you've passed away and into their own names or their siblings' names, whatever is ordered in that trust document. So you avoid probate. Probate court is like any other court. It's public. I can look up who's filed a probate action and I can see the details of those orders. Depending on the probate court, I might have to pay a little bit to download the documents, but they're all there for public consumption. The transfer can happen, immediate might be a little extreme, but transfer can happen in a number of weeks instead of a year and a half plus for the probate courts. And you and your successor trustee are in control of the whole process, not a judge. A lot of people come and tell me they want a irrevocable trust, and they don't have a trust to begin with. They don't have a will. They want an irrevocable trust. So I'd like to cover this a little quicker, but an irrevocable trust is a fantastic tool, but it's not a fantastic tool if you aren't above the federal inheritance tax limits, which right now I think are around 12 million. Savinder can probably help me with that. But
Yeah, 13.9.
13.9. So if you're not passing to your children or to whoever your beneficiaries are, if you're not reaching that 13.9, there's not a lot of reasons to talk about an irrevocable trust unless there's some health and public benefits reasons. So the biggest issues with the irrevocable trust is it's locked in. And sometimes it's locked in no matter what you want in the future. It's irrevocable by name, and it's also irrevocable by logistical and practical means. We put things in irrevocable trusts sometimes for people that have benefits, autistic adults who, if they have Social Security or other health benefits, we put their assets in an irrevocable trust so they don't have access to it. Only their trustee has access to it. And that helps us create a barrier where the government doesn't try to access their assets as payment for their benefits. So we do use them in certain circumstances. It's not completely unknown, especially given the rates of people with autism these days. But it's not a estate planning technique unless your assets are well above the federal inheritance tax limits. And it's extremely expensive compared to a revocable living trust. Once you set up a revocable living trust, there's no annual fees. There's the only thing that happens is when you maybe have another child or buy another residence. Those sorts of changes are relatively small, but it's revocable, and we can always make changes to it throughout your lifetime. I like to cover this for property investors. A lot of people have one or 20 rental properties. In California, we have Prop 19 was passed in 2021. And under Prop 19, we limit the parent-child real estate exemptions to the residents. So in the example down below, if a parent or grandparent purchased a house in 1988, I wrote this example when I wrote these slides because the day before I had this phone call. Purchased the house in 1988. It was $180,000 at the current time that it was assessed at 180. The current market value was 2.4, but the parents, when they passed away, they had just passed away last year. We're paying about $2,200 in total tax. My client was the child who had inherited. He was an only child. He had inherited the property, and he was questioning whether he had to move into the house as a residence in order to qualify for these tax benefits. And the answer was yes, because if he didn't move into the house and it wasn't the parents' residence, then the exemptions are gone, and that even though the property transfers without probate, you're still looking at a jump of annual property tax from $2,200 to $28,000 just because of Prop 19. So we need to consider the residential aspects of everybody. And if you're going to take your house, if it's in the trust and you're deciding to move out of the house and it's not going to be your residence at the time of your passing, sometimes we're going to lose some of these benefits, and we want to look at other ways of passing the home on to the children so that they don't have this permanent, almost $30,000 raise in property taxes. Okay, the next two documents are for if you're still alive, but something's happened to you. You're incapacitated. Power of attorney, there's lots of different versions of powers of attorney. There's specific powers of attorney for completing a single transaction, like buying a house. And there's really general powers of attorney that cover everything. When we're talking about being incapacitated, we're talking about a durable power of attorney. It survives your mental health, basically. If you're in an accident or you become ill, that durable power of attorney lives on for past your sickness. A durable power of attorney grants the agent who you select. Again, it could be your adult child, it could be a friend, other family member, but it's somebody, it's these people that you name as executors and trustees. They should be somebody who doesn't mind a little bit of paperwork, because these are transactional issues. They do involve a bit of accounting and dealing with accountants and lawyers. The agent has access to your accounts immediately if they have this. We write the powers of attorney so that they don't give your agent the authority now. They only give them the authority when something happens to you and a medical doctor or two medical doctors determine that you become incapacitated. So they can't do anything with it while you're still active. They can only use these documents if you need them to use it in the situation they're prepared for. It allows them to manage your properties and bills, handle business affairs. It keeps the courts out. It's a lot less expensive than a conservatorship, and you can put one in place. It's one of the fastest documents to put in place. It's literally a 10-minute conversation for a power of attorney, and a couple of days for us to prepare it. The other option, if something happens to you, you become incapacitated, is a conservatorship. This is a process through the probate court. It usually takes 3 to 6 months, and the legal fees are going to be between $5,000 and $15,000, usually depending on if somebody's contesting it or not. So if somebody's contesting it, you're looking at more legal expenses. A court investigator is often assigned and required. The court reviews it every single year. It's supervised by a judge, and it's public information in a lot of cases. It also creates an opportunity for family stress and actually family just butting heads. The conservatorship process, the person we're getting it over never likes the process, because if they're still cognizant, they know that they're losing their rights, even though they're incapacitated. And other family members will usually differ, at least to some extent, on what's happening. So it's using the power of attorney. You select which family member or other person you want to be in charge. It avoids the whole court process around the conservatorship. When we're doing a 1031 exchange, the conservatorship process doesn't happen fast enough. So if you have rental properties and you're upgrading your rental property, you're selling one property to buy another property, and you're trying to defer the taxes on those properties, it's a very common investment strategy. You have some very hard deadlines. You have a 45-day identification window. There's no stopping it, even for medical reasons. You have a 180-day exchange period. That means you have 180 days to locate your new property. You don't have to close escrow in 100 days, but you have to locate and identify that property. If you don't do these things, if you've already started the 1031 exchange process, you're gonna have to deal with a very large tax bill, especially if it's on commercial property. That 1031 exchange doesn't stop if you've already started it. So having a specific 1031 exchange section in your durable power of attorney is extremely important if you own rental property and if this is something you engage in. The final document, and this is usually the hardest one to talk about, is the Advanced Healthcare Directive. The Advanced Healthcare Directive is a document that, as it says on the slide, it literally speaks for you in two different ways. Again, you're incapacitated. A doctor has identified that you're incapacitated, and your healthcare agent is then in charge of the living will portion. There's two portions of this. One is Who decides the your healthcare decisions if you can't, if you've been in an accident or you're too ill to make your own decisions? Who's going to make the basic decisions when the doctors are asking? Again, you assign somebody you trust. And I often have people select somebody different for the power of attorney because they want their uncle to be the power of attorney, but they want their sister to be their healthcare agent. It doesn't have to be the same people across these documents. Who's the best person, the closest in your way of thinking to help you with your healthcare decisions or to talk for you if you're unable? And then there's a second part of this document, the living will portion, where you make some of those decisions that are likely to be needed for yourself, even without your healthcare agent being involved. And that's life-sustaining treatment. Do you want artificial nutrition? What limits do you want to put on pain management and end-of-life care? You can determine all of that in this document before you're ever in those situations. So it's not a decision that your healthcare agents have to face because you've already made these harder decisions. Uh, Without a directive, California, and this is the same with a will, California law defaults to next of kin, and there's a specific order. It goes, if you're married, it goes to your spouse. If you have adult children, they have to be over 18 because they're making your medical and financial decisions. It'll go to your adult children. If you don't have either of those, it'll go to your parents and then your siblings. The problem is, other than the spouse, most of those can be multiple people. And as we know in families, people don't always get along. So a lot of the law that Savindra deals with will and trust fights over these things is adult children thinking that mom or dad wanted something different. And even though they all have the right, they all have the right. So now we've got another potential court case in the middle of a healthcare problem, which sometimes can't wait for the court case to be decided. So of the urgent items, sometimes the healthcare directive is one of the most, because if you're in a medical emergency and you don't already have this in place, we don't often have the time needed for a judge to make these decisions. A lot of my clients are medical professionals. We set up medical corporations and we deal with people that practice medicine, mostly because my wife practiced medicine and I've been involved in that for years. But doctors and nurses do not have a healthcare directive at any higher rate than the general public. And yet they know some of the same things I know and a lot of you know. In the middle of an emergency situation, without that healthcare directive, in the emergency room when the doctors are trying to decide who has the authority to, excuse me, before he walks on the keyboard, deciding who has the authority to make the decisions, that sometimes healthcare treatment can be stopped or at least not fully followed because there's no documentation of who has the ability to make the right decisions. And hospital administrations tend to be a little bit shy of allowing people in under their employ to make decisions that could get them into a litigation situation. So all four of these documents are an estate plan. When you hear the term estate plan, it's all four of these. It's an integrated system. You're statistically more likely to need the POA and healthcare directive, at least for a short period of time, than you are to skip over them and go directly to the will or living trust, which means you passed away without some other incident. We don't generally most of us aren't so lucky to jump straight to the will and living trust need. We generally have a healthcare issue prior to death, and that's where these other two documents come in. If you remove any of these, there's room for error and gap in your personal life, with your real estate, with your children and the beneficiaries, the guardians, as well as your own healthcare and end-of-life care. So if the only exception to this is if you don't own real estate in California and we determine you only need the will. If you own real estate, you need all four documents. This is the most common mistake. We see this every day. Our estate planning department, Ashley Sanchez, reaches out almost every day to multiple clients because they don't contact us at the end once we finish everything. When a trust is finished, we have to put the house in the trust. It's included in our agreement. It's included in the price, but some clients don't follow up. And a trust that owns nothing, it has no, this says it does nothing, but it doesn't actually exist. It doesn't do you any good. So I like to point this out. So later, when we're reaching out to you, you realize that we're trying to finish this process. We always have to fund a trust. An unfunded trust is not an active entity. And if we don't put the house in the trust or other real estate in a trust, that real estate has to go to probate, despite the fact that you took the time to set up the trust. We just didn't make the final deed transfer. Okay, we get asked these questions a lot. So there are basically four different ways to set up these documents. The biggest risk are templates, whether they're do-it-yourself or attorney templates. Templates are just like when you set up a LLC online. It's the same template used by 850,000 different people. It's not customized to your situation, to your assets, to your beneficiaries, or to your wishes. There's some fill in the blanks that help, but there's a big risk in filling out templates. My father-in-law is 86 years old. He still practices estate planning with some of his older clients, and he uses a template that I update every few years for him because he won't use software to do it because he doesn't know how. I would suggest steering away from both templates, especially do-it-yourself forms on the internet. A lot of times these end up putting you in probate anyways because they're not there's both the language is not correct, either it's old or it was actually for another state, another jurisdiction, or what's covered in it is just not enough to help you completely avoid probate. The online portals are basically the same as templates. They just have a more automated system on there. There's no attorney involvement, and when you want to make changes, you have to start over because they can't make changes to your process. So with us, once we have your stuff in the system, if you're adding a child, a house, or anything else, we can make changes fairly quickly and fairly easily. We use drafting software. Currently, the two most popular drafting software products are called Wealth Cancel and Interactive Legal. These are extremely complex drafting systems that help us with your 30-page trust documents. They really help us to make sure everything's customized to your needs. If you have a child with special needs, you just saw one of my cats, if you have a cat and you want a pet trust, we're able to customize this to your needs and your assets and your children. The Bay Legal approach. Almost all of our clients, including the extremely wealthy ones, they start with a revocable living trust for their residents. There are other situations where a revocable living trust might stand alone for a second property or a complex family situation. But almost everybody starts with that revocable living trust. It's the centerpiece of where you determine everything about how your assets are going to be divided. You don't need to do it anywhere else. It can all be in the trust, and the trust is your comprehensive plan for when you pass away. We can coordinate all the documents together. We make sure that your power of attorney and your trust, your will, and your healthcare directive don't. Sometimes there can be there's especially in the trust there you can put some healthcare information in a trust or a will, but we want to make sure we keep them separate so that they don't contradict each other. We add the protections intentionally if in our consults we find out that you have a large say rental portfolio. We're going to probably suggest a more complicated structure to help protect not only your assets while you're alive, but also keep this structure and avoid probate court for everything and not just your personal residence. But it starts around that personal residence. And then we make sure we fund the trust. As long as you reply to us after we've executed it to get everything notarized. There's lots of other, I used to have this slide really long, but there's lots of other thing that not everyone needs, but a lot of people need. LLC structuring for liability separation. If you own 5 rentals and they all have $1 million of equity, you don't want all 5 rentals in your trust or in an LLC where one person, there's a fire, one person is killed or injured, then they can sue you for that, all your assets, because they're all in the same structure. So we want to break these structures up to make sure that you're protected. We layer insurance as a first line of defense, umbrella policies. We can advise you on based on your assets, what you should be looking for. If you are in the fortunate situation to need some Medicaid, federal inheritance tax planning, or you're in the life insurance, Medicaid, or other um, social benefits issue, we can help you with those irrevocable trusts. We structure irrevocable trusts a lot for minor children. Once their parents pass away, they're in place and ready to go, but the children don't necessarily need them while the parents are still around to take care of them. Advanced trust design as wealth grows, the life insurance trusts, if you're looking at a substantial estate and you're trying to plan around the inheritance taxes, we have lots of options. They're just not necessary unless your assets are to that level. And then entity planning and business scaling. Okay. If you'd like getting help, if you'd like help getting this right, we have webinar pricing for all of our attendees. Our usual package for a single person for all 4 documents is $3,500. If you're attending today, it's $3,000. And then if it's a couple, a married couple, you don't actually have to be married. We can have a trust for unmarried couples. Then it's usually 4,000. It's 3,500. If you need more or less than all 4 documents, like I said, every once in a while somebody doesn't need a trust. This price will be adjusted, but you still get the $500 discount. If you'd like to move forward and talk to either myself or Savindra for and lock in the pricing, Jack can help you take a $250 deposit. We'll set up a consultation with either Savindra or myself, depending on your asset structure, and start the process of getting this done. It usually takes about 2 weeks from the time we have our second meeting. The first meeting's for us to learn about what your needs are. The second one is for the decision making. Who do you want to be your executor? Who do you want to be your healthcare officer? And how do you want your assets to be split up once you pass away? Now, Jack, is there anything in the chat?
Yes, we do have 2 questions here from Rosa. Would you be able to give more details about unfunded trust?
So there's a few things to say about unfunded trusts. I'll give you the couple highest frequency, and then you can let me know if your question's a little different. There's a process in California based off of a case called Hegstad, where if a trust is funded, but with the $10 we usually fund a trust with, but we didn't move the property in there, depending on the county, we can submit a Hegstad petition and try to move the real estate into the trust after you've passed away or become incapacitated. It's not a guarantee, and there are some judges known for being easier than others on this, and it just depends on the county. But sometimes we can move the property into a funded trust, but where the property hasn't been transferred. An unfunded trust is an unfunded trust. Funding is a requirement for the trust to be an entity. So I would have to know what the question is exactly to answer any further than that, Rosa. I'm trying to pull the chat up because it's hiding in a toolbar.
Okay, Rosa got it now. So we can move on to the next question
Okay.
from
Yep.
A. Simic. Can my husband and I have a separately owned assets in one trust, or do we need our own separate trusts?
That's a very common question, especially second, third marriages, or we inherit something from our parents that's our separate property. It depends on what you want to do with it. If we can put them into the same trust but there are some, from my earlier slide, because that trust is owned differently than how the property is, you are probably going to look at a tax reassessment from the assessor's office on your property taxes. So you usually don't want to do that unless you both agree we want to put it together. It's actually both of ours. We'll make a pre-transfer. There's a spousal exception. We can transfer it 50% into each spouse and then put it into the share trust. And those two steps, and we have to do them in these steps, we can't do it at the same time, will avoid the property tax reassessment. But it really depends on what you want to do with it.
Cool. I hope that answers your questions.
I think
So,
Jocelyn had a question. I think we decided that if they could contact you in 24 or 48 hours, right, Jack?
yep.
For the $250.
Yes.
If you need to talk to your husband, obviously.
Can
talk
I
to him.
ask a question?
Absolutely. I'd be
I
happy if
actu-
everybody
yeah,
talked.
I'm actually not a California resident. I live out of state, but I do have an property there, and I do have a trust currently, a revocable one. But because of having another property in California, I wanted to make sure that that property goes into the trust, and my attorney here in Maryland prefers that I manage that through a California lawyer.
Yeah, we can definitely help you with that. It does again, you just want to at this point probably to transfer it. We'd want to see the trust, but just transferring the California house into the trust might be enough.
I mean, that was done like 5 years ago, and I'd like to revisit it as well to make sure that it's all covered. So I'm willing to engage, but I just want to make sure I discuss this with my husband before I make any commitment with you guys.
For sure, definitely. Yeah, we can definitely help you on that.
Awesome. We have another question from Anita. Isn't it better to get a law firm in the state where you have your legal residence?
So it depends on what your asset mix is. Some people. So one of the exceptions to everything I showed you is sometimes we do have a trust without a will, without anything else, because it's what we call. Some states have a legal definition for this. We just call it this because of how they do it in other states. We call it a property trust. There's not really a property trust in California, but if a revocable living trust, all it does is hold a property for probate avoidance, we still refer to it as a property trust because it's not doing all those other things I talked about. It's just saying this house is going to this person or this charity, and it helps to avoid probate. But it doesn't mean you can't put it into a trust in your home state. We just need to make sure that it satisfies California law so that you can avoid probate in California.
That's my understanding.
Rosa is asking if the webinar is recorded. It is recorded, and we will post it, right, Keegan? He's shaking his head yes, nodding his head yes. And if you go to the YouTube channel, I do discuss some of these same things there. It's a little more TikTok-y, but it's up there. Okay, I'll check the questions before we end. I always like to ask if you found this useful. We survive, and a big part of our marketing is our Google reviews. So if you found this useful, even if you're not planning on getting a trust in the near future or a will, it would be great if you could leave us a Google review to let other people know that we are providing these, and so we can keep doing this for potential clients and just for people looking for education. Speaking of education, somebody asked in the form when you signed up about transfer on death deeds. I see a lot of transfer on death deed discussion. It's a deed that, so Keegan is my son. I could set my residence with a transfer on death deed that says when I die, my house transfers to Keegan. And that does avoid probate. The issue is, and the reason most attorneys don't even bring this up, if Keegan was in that car accident with me and he's dead and I'm dead, then the beneficiary doesn't exist. And now it's going into probate with no instructions for the judge to know who I want the house to go to. And I have 4 kids. So now you've got, Keegan just passed away. You've got 3 kids fighting over it potentially. So I don't like anything that leaves that reality open. And younger kids don't tend to transfer property quickly like they should. They'll leave it for a few years, and that leaves more ability for things to go wrong. So I think there are companies out there. We used to do a lot of work with MetLife. They try to push transfer on death deeds a lot. You don't need an attorney to file one. It's also, I think, depending on the family situation, almost malpractice to file one, because if both people are dead or incapacitated, you've got a really big problem. So I don't suggest them for that very reason. And Keegan, did you put the link in the chat? You did. Thank you. And here's our contact information. If anybody would like to speak with one of the attorneys or Jack to schedule an appointment, we'll be here for a few minutes. Or if you just want to ask any more questions.